Ladies and gentlemen, I have the pleasure to announce the arrival of the High Commissioner of India, His Excellency Shri B.N. Reddy, and our special chief guest for this evening, Shri Tommy Thomas. Ladies and gentlemen, on behalf of the High Commission of India in Kuala Lumpur, it's indeed my proud privilege to welcome you all and our invited guests today for this very special evening, as we are here to celebrate the Constitution Day of India, which is also known as the Samvidhan Divas. I would like to welcome His Excellency Shri B.N. Reddy, High Commissioner of India to Malaysia, His Excellency Dr. Joachim Bergstrom, the Swedish Ambassador to Malaysia, the Deputy High Commissioner Mrs. Archana Nair, founder and members of the Malaysia-India Heritage Group, distinguished guests from the Academia, the community associations, members of the media, and officials from the High Commission of India, Kuala Lumpur. I'm also very, very honored to welcome our special guest this evening, Tan Sri Tommy Thomas, barrister and the former Attorney General of Malaysia. A warm welcome to you, Tan Sri. This year's Constitution Day celebration is a part of the Azadi Ka Amrit Mahotsav celebration, which is also the commemoration of 75 years of India's independence. We will begin today's program with a felicitation of our special chief guest, Tan Sri Tommy Thomas. May I kindly request His Excellency Shri B.N. Reddy, the High Commissioner of India to Malaysia, to kindly felicitate Tan Sri Tommy Thomas. Thank you, sir. Now, may I kindly request His Excellency Shri B.N. Reddy to deliver his welcome remarks. I'm so sorry.
Thank you, Padmini. Tan Sri Tommy Thomas, distinguished former Attorney General, my good friend, Ambassador of Sweden, Mr. Dr. Joachim Bergstrom, Tan Sri Dato R. Palan, Mr. Kalidas Krishnan, President of the Bar Council of Malaysia, distinguished colleagues from Malaysia-India Heritage Foundation, distinguished heads of various organizations based in Malaysia, friends of media. Today we are gathered here to celebrate Constitution Day of India, a very special day in India's democratic tradition. It was on this day 70 years ago in 1949 that the Constituent Assembly adopted the Constitution of India, which later came into force on 26th of January 1950. The observance of 26th November as the Constitution Day is a vision of the Prime Minister of India, His Excellency Mr. Narendra Modi, to give due recognition to this historic date. Prior to this, we were celebrating or observing it as a National Law Day. And in 2015, it was also an occasion for us to start this process, as it was a tribute to the father of our Indian Constitution, Dr. Bhimrao Ambedkar. And it was the 125th birth anniversary after Dr. Ambedkar. So it is this tradition that now today we are following. And speaking earlier today in the Central Hall of the Parliament in New Delhi, President His Excellency Dr. Ramnath Kovind said, I quote, "The development journey of India has been progressing on the strength of our Constitution, and Indian Constitution binds the nation." In fact, our President led the nation in reading the Constitution at 11 a.m. Indian time. I was just briefing Tan Sri a little while ago. The essence of all religions and cultures that form part of the microcosm of India find reflection in the preamble to the Constitution of India. In fact, globally, all Indian high commissions and embassies joined the preamble reading as much as possible, depending on the time zones. And a massive global campaign was launched today to encourage Indian citizens to undertake reading of the preamble. It is a mark of their respect to the Indian Constitution. And I did so, and I've also tweeted about it. Excellencies, ladies and gentlemen, the democracy in India has not only survived but also thrived in spite of various challenges over the last 75 years. This is a testimony to not only the strength, flexibility, and tenacity of the Constitution, but also the vision of the members of the drafting committee of the Constituent Assembly itself. Over the last 72 years, the Indian Constitution has proved itself to be a living document, as it is evident in the numerous amendments to the Constitution which have been effected from time to time as per the process and proceedings of the Indian parliamentary proceedings, and to keep pace with the changing realities. In fact, these amendments have, however, not changed the core values of the Constitution. The role of Indian Constitution was envisaged as a Magna Carta of socio-economic transformation to empower the state to enter into the realm of Indian society and transform it by eradicating deeply embedded economic, political, and social hierarchies. Believe me, this is work in progress. But at the heart of it is the foundation that is laid in our system through the Constitution. Dr. B.R. Ambedkar, the father of our Constitution and chairman of the drafting committee, had said, I quote, "The Constitution is workable, it is flexible, and is strong enough to hold the country together both in peacetime and wartime," unquote. Excellencies, ladies and gentlemen, I believe it is critical that we celebrate and observe such historical days to pay tribute to the framers of the Constitution and also to recommit oneself at the individual and national levels to uphold the great values as enunciated in the Constitution. Friends, Malaysia and India share age-old ties. Our relations are deeply rooted in democratic traditions anchored by the respective constitutions. We have a lot in common in our democratic journey. Today is an occasion to look at how framers of the Constitution of India and Malaysia engaged each other in several ways. It is here and in this context, we are delighted, Tan Sri, to have you to speak to us on this very important subject. I owe deep gratitude to Tan Sri Tommy Thomas for consenting to speak to us today. With this, I thank you everyone for joining us, and we look forward to the sort of keynote address from Tan Sri Tommy Thomas.
Thank you very much, sir. Next, we present you a 2-minute animation video which is themed India, Spirit of Freedom, which is commissioned by the Ministry of External Affairs, Government of India. biggest democracy. Ladies and gentlemen, it's my privilege now to introduce our special guest, Tan Sri Tommy Thomas. Tan Sri read law at the University of Manchester and international relations at the London School of Economics. He is a barrister and was called to the Malaysian bar in the year 1976. As a barrister of some 45 years standing, Tan Sri Thomas has had the privilege of appearing as counsel in many landmark cases in various branches of the law in all courts of Malaysia, including the Privy Council in London, which was Malaysia's highest court till the year 1985. He has been singled out for over 20 years as one of Malaysia's leading litigation lawyers by the independent international publications such as the Asia Pacific Legal 500, which Lawyer Who is Who Legal, the International Who is Who of Business Lawyers, Commercial Litigation Lawyers of Asia, and Chambers of Asia. Tan Sri Tommy Thomas was appointed the Attorney General of Malaysia in June 2018, and he was the first private practitioner since the World War II appointed to the office direct from the bar without any experience in the public service. After serving as Attorney General for over 20 months, Tan Sri returned to the bar in the year September 2020 as consultant, also resuming his career as a litigator, having made several appearances in court. Tan Sri Thomas regards himself as a social scientist with interests in economics, politics, and history. He has also written extensively and presented paper in all these subjects, as well as diverse legal matters. He has also published 2 books of essays. His memoir, My Story, Judiciary in the Wilderness, published in the year January 2021, which was critically acclaimed and is also a bestseller. With great pleasure, I now invite Tan Sri Tommy Thomas to deliver his keynote address on this occasion.
Your Excellencies, distinguished guests, ladies and gentlemen, I regard it as a singular honor to be invited by the Government of India to deliver an address to commemorate India's Constitution Day. I wish to thank the High Commission of India to Malaysia for hosting this most auspicious event on this historic day when the Constituent Assembly, quote, adopted, enacted, and gave to ourselves this Constitution, unquote, 72 years ago. I am indebted to His Excellency Sri B.N. Reddy, the High Commissioner of India, for the generous invitation to share my thoughts on this most important of political covenants. Mahatma Gandhi declared in 1922 that Swaraj, that is independence from the British and self-realization, required Indians to shape their own destiny, that only in the hands of Indians could India become herself. Swaraj would not, the Mahatma be the gift of the British Parliament, but must spring from, quote, the wishes of the people as expressed through their freely chosen representatives, unquote. The desire for a homemade constitution, instead of one drafted in the Colonial Office in London and passed by Westminster, was very much in the minds of the architects of India's independence. Thus, they did not wish the retreating British to be involved. Rather, the Constituent Assembly was tasked with the grave responsibility of writing the Constitution. The Constituent Assembly, indirectly elected by the people in 1946, held its first session on 9th February 1946. Although the assembly was in effect a one-party assembly dominated by the Congress Party, it was representative of India. More fundamentally, its internal decision-making processes were democratic and fair. The leaders of Congress who led India to independence in August 1947 and then governed it were also the most influential members of the assembly. The provinces, the princely states, and the 3 communal groups, that is the Muslims, the Sikhs, and the general, that is Hindus and all the other communities, were also represented. As the Constituent Assembly deliberated, the Indian Independence Act, passed by the British Parliament, came into effect on 15th of August 1947, and India assumed her rightful place amongst the free nations of the world. And for Malaysians, that was 10 years before we joined that group. This act further conferred legality to the Constituent Assembly, elevating it to the legislative branch in the newly independent union as the Dominion Parliament. Rajendra Prasad was elected President of the Constituent Assembly. The appointment of Bhimrao Ambedkar as chairman of the key drafting committee turned out to be a singular success. Not only was Ambedkar not a member of Congress, he had public disagreements with Congress and with Gandhi for over 2 decades. This was, however, not held against Ambedkar. He was personally invited by Nehru to serve. Mention must also be made of B.N. Rao. As constitutional advisor, Rao's advice was often accepted in the Assembly's inner councils, although he was not a member. As a preeminent jurist, student of comparative constitutional history, and skilled draftsman, Ambedkar and Rao played important roles to help create the Constitution. The Constitution was adopted by the Assembly on this day, exactly this day, in 1949, and came into force on Republic Day, 26 January 1950. The Indian Constitution's indigenous nature and origin has been a major reason for its enduring success. That the same men responsible for drafting the Constitution were also responsible for governing the country gave the Assembly an immediate understanding of the issues required to be dealt with in constitution making. The big four in Congress, that is Jawaharlal Nehru, Vallabhbhai Patel, Maulana Azad, and Rajendra Prasad, brought their immense prestige as founding fathers, along with their knowledge and working experience of the day-to-day affairs and problems of government. Idealism was tempered by pragmatic realism. If the United States had Washington, Jefferson, and Madison as its founding fathers, India had its own array of distinguished greats. Indeed, no other people gaining independence after the Second World War was so blessed with leaders of such experience, talent, love for democracy, and personal character. The Indian Constitution provided fidelity to the universal principles of liberty, equality, and fraternity, the French influence. It happily adopted Madison's Bill of Rights from the US. From the common law of England, it accepted constitutional conventions and fundamentals like separation of powers, rule of law, independence of the judiciary, and in part, Dicey's principles. The directive principles of state policy were derived from the Irish Constitution. No wonder that this eclectic approach to constitution making led scholars to describe it as a cosmopolitan constitution. The Supreme Court of India, the apex court, was established under the Constitution also on Republic Day. All appeals to the Privy Council in London ceased thereafter. Now, a foreign observer can wax lyrical about the ways and means by which judges of the Supreme Court of India have creatively pushed the boundaries of constitutional law to its outer limits, further than any other court in the world. Time constraints, however, do not permit me on this occasion to do justice to the development of judge-made law. In fact, they take volumes in the textbooks. Rather, I shall briefly highlight 3 areas of public law that present challenges to every society, regardless of any claim to political maturity. And they are constitutional amendment, public interest litigation, and the facilitation of fundamental liberties, where Indian jurisprudence thrives. So let's take constitutional amendments first. The designers of the Indian Constitution did not foresee the Congress domination of Parliament in the Nehru days, which meant that constitutional amendments were easily secured. The 2/3 majority posed no obstacles. The rush to constitutional amendments continued unabated during his daughter Indira Gandhi's prime ministership, including endeavoring to rein in judicial independence. The stage was set for a confrontation between the executive and the judiciary. In Kesavananda Bharati and Kerala, which was a 1973 case, lands belonging to a religious endowment were expropriated through legislation which was rendered unchallengeable in court by a recent constitutional amendment. The Supreme Court of India was invited by the nation's leading constitutional lawyers to revisit the validity and extent of such constitutional amendments. A special bench of 13 judges sat for 70 days. Yes, that's 70 days, 70. Now, Malaysian lawyers will say you'll be lucky if you get 70 minutes. The 11 judgments exceeded 800 pages in the law reports. The majority enunciated a completely new constitutional doctrine. While Parliament's power of constitutional amendment was extensive, it was not absolute, and any use of that power to alter the basic structure of the Constitution would be impermissible. Without an implied limitation, Parliament could abolish general elections, perhaps even the entire constitution. Put simply, the legislative branch, itself being a creature of the constitution, cannot increase its own constituent power, nor can it arrogate to itself the power to radically alter or destroy the constitution or its essential features, like the power of the judicial branch, for example, a co-equal branch, in the guise of constitutional amendment. Thus, Parliament operates under inherent and implied limits. Parliament is without power to make wholesale changes or a total review which would render the Constitution a wholly different document from its original version. Kesavananda represents the high watermark of constitutional interpretation, not just in India, but the entire common law world. As one would expect, the majority in Kesavananda did not identify what constituted the basic structure. Subsequent cases did, and they include topics like secularism, independence of the judiciary, judicial review powers of the High Court, freedom of speech within Parliament, free elections, and the rule of law. And all of these doctrines or themes have been accepted as part of the basic structure of India's constitution. Now, public interest litigation. Now, that involves a court relaxing the strict requirements of traditional adversarial style litigation in a common law system in limited circumstances to allow indigent persons or disadvantaged groups access to justice. The most critical relaxation was widening the test for standing to sue. If the person who has the requisite locus standi is too poor to sue, or anyone else acting in good faith can move a petition on his behalf, the Supreme Court's expansionary approach included acting on letters written to it, thus bypassing the courts below and giving the apex court original jurisdiction. In order to do practical justice, judges of the Supreme Court are empowered to investigate the matter before them in order to secure the facts and other data that would be necessary for a decision or a determination to be made by the court later. The extent and range of cases undertaken through PIL in 4 decades is truly remarkable. What began as complaints about prisoners and gross human rights abuses has moved to bonded labor, tribes affected by development projects, environmental protection, public health and sanitation, conservation of wildlife, and public education. PIL has thus demonstrably increased access to the courts for the poor and ostracized members of society and provided benchmarks for proper conduct for bureaucrats. Such court intervention, however, has not gone without criticism. Thus, Upendra Baxi, a leading constitutional observer in India, stated, and I quote, "The Supreme Court since 1980 has become the third chamber of Parliament," unquote. Then fundamental liberties. Now, they are enshrined in Part 3 of the Indian Constitution. In some 15 articles, free speech, freedom of religion, equality, and the like are given hallowed status. For present purposes, I just wish to focus on Article 21, which is our Article 5, which states that no person, quote, shall be deprived of his life or personal liberty. Life has been recognized as the most precious right and means much more than mere animal existence. Right to life was expanded to mean to live with human dignity and includes the finer graces of civilization. The right to a fair trial and a fair procedure entail the right to free legal aid services. Personal liberty has been interpreted to include the right to education, the right to health, right to livelihood, right to food, right to a clean environment, privacy, sexual harassment, telephone tapping, and even the concept of sustainability. Given the sheer breadth and width of rights being read into Article 21, concern has been expressed whether a hierarchy of rights ought to be tabulated. The dangers outweigh the incremental development on a case-to-case basis. Ultimately, personal liberty is very much the judge's reasoned view of space allotted to an individual by a democratic and open society. Article 21 has thus developed into a repository of manifold human rights by the courts, giving substantial content and flesh to the dry words life and liberty. So no one would imagine that those two words, life and liberty, have given birth to so much jurisprudence. Now let me briefly touch on the Indian influence on Malaysia's constitution. India's independence on 15th of August 47 and establishment as a republic under a supreme constitution on the 20th of January 1950 inspired our own founding father Tunku Abdul Rahman, who was legally trained in England and comfortable with the Westminster system of government and who knew Nehru personally. Hence, it was Tunku Malaya's first popularly elected chief minister and our first prime minister who insisted on a commission of experts from the Commonwealth to study and advise on a written constitution for independent Malaya. The Constitutional Commission, established in 1956 under Lord Reed, a Scottish law lord, comprised 5 distinguished jurists, including former Chief Justice B. Malik of the Allahabad High Court. Reed's commission borrowed heavily from the Indian Constitution, including the chapter on fundamental liberties. The supremacy of the Constitution is also recognized in Malaysia. Other similarities include federalism and judicial review. Justice Malik's influence was thus substantial. It therefore comes as no surprise that from the first constitutional case to come before our courts, just shortly after Merdeka to the present, Malaysian Council invariably refer to cases decided by the Supreme Court, and our judges often quote and rely on these cases. Your Excellency, I can personally vouch for this aspect of Malaysian constitutionalism. In nearly every case that I have appeared in the courts, I have referred to Indian case law. Some concepts and doctrines have been accepted and form part of Malaysian law. Regrettably, some have not been accepted. PLI, public interest litigation, is a good example where our courts have scrupulously avoided entering into, and in my view, sadly. In February 1980, Lord President Tun Sufyan was given the high honor of delivering the Chitali Memorial Lectures in Bombay and Nagpur. The prestige of this lecture series is marked by the international caliber of the distinguished speakers. The speaker in the previous year had been Lord Denning, one of the greatest judges of the 20th century. Tun Sufyan, who undoubtedly ranks among Malaysia's most cerebral judges, published his talks into a book entitled Malaysia and India, Shared Experiences in the Law. Tun Sufyan reminded readers that the Indian influence had accompanied British rule over the Straits Settlements from the early 1850s. The Criminal Procedure Code, the Penal Code, and the Evidence Act were borrowed from India. Likewise, the Contracts Act, the Specific Relief Act, and the Land Acquisition Act. Tun Sufyan also paid tribute to the contribution of Justice Malik in modeling our constitution on India's. I want to briefly touch on your accomplishments as I come to my allotted half an hour. As barristers, we must keep to our time. 7 decades provide an appropriate time frame to assess the actual working of the Indian Constitution and to inquire whether aspirations of the Constituent Assembly in adopting their homemade constitution have been met. Save for the 20-month Indira Gandhi emergency from July 1975 to March 1977, the clear, unambiguous and unequivocal objective answer would be that the Constitution, your Constitution, has served your nation and your people remarkably well. The Indian Constitution is the longest surviving constitution in the post-colonial world. It has been the model for numerous Commonwealth countries which freely and voluntarily opted for Westminster-style parliamentary democracy. A constitution, no matter how well conceived and how comprehensively drafted, can only establish institutions, confer rights, and impose obligations on paper. Breathing life into it is entirely dependent on thousands of individuals, starting with members of the 3 branches of government. The Prime Minister, the Cabinet, parliamentarians, and judges of the superior courts have their respective constitutional duties to discharge. The bar has a vital role among members of civil society, so has the media and academia. Finally, the people, who are the ultimate beneficiaries of constitutional protection. Hence, the actions of a whole host of human actors make it work. It is in this sphere that the Indian experience has been a conspicuous success. If Gandhi represented the soul and spirit of democracy, Nehru manifested in the first 17 years of the nation's life as an independent nation the democratic actions of an accountable chief executive, while Ambedkar laid the constitutional foundation for a successful parliamentary democracy constrained by the Constitution of India. The Indian Constitution also provided a durable framework and foundational structure for institutions to work during challenging times, domestically in dealing with political, economic and social changes, internationally in coping with Pakistan from partition and Kashmir, as leader of the non-aligned movement in the 1950s and 60s during the Cold War era, and as a nuclear power in more recent times. Unlike its neighbors in the subcontinent and many in the third world, the military stayed in their barracks. Never was there a concern about military coups, with the armed forces accepting civil dominance. A social revolution was brought about in India through the blossoming of civil liberties and human rights in the aftermath of oppressive British colonial rule. Central to it are the fundamental rights, directive principles, universal adult suffrage, and general elections held every 5 years, all rooted in the Constitution. The Constitution, above all, has been the source of the country's stability and its open society. State and national elections are regularly held. Governments have peacefully handed over power after losing at elections. Even when Indira Gandhi had supreme power during emergency, she yearned for democratic credibility and called for general elections, resulting in a humiliating defeat in March 1977. A constitution is worked by humans whose conduct shapes and molds the former. The politics for working the constitution resulted in a consensus, give and take approach that never threatened the body politic of the republic. In the final analysis, ladies and gentlemen, any objective audit after 7 decades would conclude the constitution has satisfied the aspirations of its makers. Many of the nation's achievements in varied areas can be attributed to the underlying constitution, its brooding omnipresence. The executive branch, prompted often by the judiciary, has shown itself to be far more flexible than even the most optimistic members of the Constituent Assembly may have expected. If I quote a famous passage by Lord Sankey, who was Lord Chancellor in the 1930s, this is what Lord Sankey said, quote, "The British North America Act planted in Canada a living tree capable of growth and expansion within its natural limits," unquote. The best compliment that a student of constitutional law can pay to any nation's written constitution is that it is a living, breathing document. Hence, vitality and growth are essential, in contrast to, say, interpreting a will. Save for short interludes as during the emergency in the mid-70s, those working the Indian Constitution have made it the heart and soul of a democracy, the world's largest. It has served as a brake against military coups, encouraged secularism, overcome some of the injustices caused by the emergency, inspired lawyers and judges outside its shores, and produced the most powerful court in the world, a court which protects the rights of some 1 billion people. In my respectful opinion, the most deserving epithet for the Indian Constitution is the banyan tree, which incidentally is also India's national tree. The banyan offers massive shade and protection. Its aerial prop roots provide greater stability than the normal single trunk of most trees. It is synonymous with longevity. Long may India's constitution and its banyan trees flourish. Thank you very much.
Thank you very much, Tanshri, for sharing your profound insights on the Indian Constitution and its influence on other constitutions, including Malaysia's. Ladies and gentlemen, Tanshri has been very generous in agreeing to engage in a discussion with your audience today. So may I kindly request anyone who has got a question to introduce yourself before posing your question. And in the interest of time, I request that the questions may be kept brief and precise.
If I may start, Tanshri, Tommy, Andrew Koo from the bar. Quick question. You referred to the fact that Tunku Abdul Rahman, looked very much to the idea of the Indian Constitution in wanting to frame a Malayan constitution. So I suppose my question, given some of the things that are happening in Malaysia, is why didn't we have as wide or as aggressive or as extensive constitutional protections for fundamental liberties as expressed in the Indian Constitution? Ours seems to be a little bit of a truncated version of the Indian Constitution in terms of its depth and its width. Maybe you don't agree with that assessment, but if you do, perhaps you could say your thoughts why it ended up being so. Thank you.
Thank you, Andrew. For members of the audience, and Andrew is a well-known practitioner in the bar, so I know Andrew well. Can I start by saying I better be careful in saying I don't know whether Tunku was terribly influenced by the Indian Constitution. Tunku was an Anglophile and studied in Cambridge and spent so many years in the UK. He wanted Ivor Jennings to be in the commission, that we know. But the point was that Tunku wanted a constitutional commission of experts, not local lawyers. The rulers wanted local lawyers and local production of the constitution to contrast with India. But Tunku didn't want, Tunku in particular, and he was quite happy to have an Indian representative, which is Justice Malik. But I am not sure whether Tunku himself knew much about the Indian Constitution, because the Indian Constitution was only that 4 or 5 years old then. The Constitution is 1950, this happening in 55, 56, 57. My first point. But to answer your question, no, I would say that the fundamental liberties that appear in Part 3 of the Indian Constitution, which is mirrored in Part 2 of our Constitution, we adopted it from there, and Justice Malik would have been very instrumental in that. Is drafted in very similar terms, and the constitutional amendments were also same, 2/3. And what I said just now about the Congress Party of Nehru dominating Parliament in the first 17 years of life is exactly what happened in Malaya. We had the Alliance Party, Alliance Coalition of 3 parties. They had 1 party, the Indian Congress Party. But there was getting the 2/3 majority was very, very easy for both countries, and those were the amendments. But the big difference is the Indian courts throughout, except for that little interlude, would strike down constitutional amendments passed on a 2/3 majority as being unconstitutional, and therefore protecting and enlarging the fundamental liberties. Whereas our courts, as you know, never did that. So that is the result. It's a failure on the part of the courts, sad to say. Because in both cases, the executive was minded to shrink space. Parliament was controlled by the executive. It was the judiciary left to do its duty. One judiciary did its duty. One judiciary has not done it so well. So the net result would be, if you ask the question, are all those Article 21 life and liberty examples of India reproduced in Malaysia? Because we've got the same Article 5, life and liberty. We don't have all of those because our judges have not accepted them. So it's the task of us constitutional lawyers. Well, we need litigants first of all. I think my big complaint now is we can't find litigants in Malaysia. When we find litigants who are brave enough to go to court, there are any number of lawyers, then we have to test it and invite the judges to follow the pattern. Thank you.
That's Sri Murugan from Malaysian Bar. My question for you is this. Should our Malaysian courts emulate the Indian judges in giving an expansive interpretation to Article 21? What are your views?
My views are not just Article 21, they should give that kind of wide interpretation to all the fundamental liberties in our Part 2, their Part 3. But more importantly for me, I think where we are really far behind is public interest litigation. And as you know, our lawyers and our judges are obsessed with locus standi and standing, and they use that as a massive obstacle to prevent access to justice. So that is one of our great black spots, and it's very difficult to convince. But even the lawyers are the lawyers are the ones who put forward the arguments. They don't want to hear the matter on the merits. So the lawyers are first of all the troublemakers. But if you have strong judges who say, "Look, don't be silly. Don't stop me from." You see, when a judge is told by a lawyer, "Please don't hear the case because the litigant doesn't have locus standi or standing or whatever, effectively you are telling the judge, don't hear the case. Shut down the court door, deny access. And judges should say, no, we are paid to, we've got our monthly salary, we are coming here, we got a case today, we're going to hear the case. And don't be silly, they must be robust. We don't have that. We have to somehow educate our judges.
I should say that the Constitution of India was drafted by the Constituent Assembly. It was like a symphony, a veritable symphony comprising hundreds of individuals. Unlike these few jurists who drafted the Malaysian Constitution. And they hailed from various political and social groups in India, discussing important issues. And in that period, in which the Constitution was drafted, so many important decisive events had occurred. The separation of Pakistan, independence of India also occurred during that period. So many different events. And so the Constitution was adapted to these events. And I think this is the greatness of this Constitution. It is really a product of the spirit and the soul of India. Thank you.
I accept that, and I think both the U.S. Constitution, which was adopted at the Philadelphia Convention, as you know, again the deliberations for about 5-6 months, and it was done by all those who were going to take part in government. So George Washington was the chairman, John Adams was there, Madison was there, Hamilton was there, and they contributed because they were going to govern, and they were governing to some extent. And India had the same experience. And that is absolutely correct, because they are, taking the Indian example, in fact the Indian example is even better, because they got independence in August of 47. So let's take Prime Minister Nehru, who was very much involved in the Constituent Assembly. So in the morning he's running the country as Prime Minister in 1947 after independence. And then in the afternoon he's going to the Constituent Assembly and helping to draft the Constitution. And of course, he's not going to actually draft, there are others drafting, but he would be there in the afternoons and the evenings, and so would Vallabhbhai Patel and all the others. So they're governing in the morning, in their ministries and in parliament, and taking part in the debate in the afternoon. It took 2-3 years. So that was very, very helpful, because they know about actual governance. Whereas in Malaya and most of the other British Commonwealth countries, whether it's Jamaica, Nigeria, most of the other countries did not follow the Indian model. They asked Whitehall, London, to do it for them. And the disadvantage is that Whitehall will send an English judge, a British judge, a couple of professors, a couple of civil servants, all from London, who won't know what is happening in Fiji or Ghana or Nigeria, as the case may be. So there is definitely, and in fact I've written a paper on that, which my paper will be circulated later on. And if you look at my footnotes, I consider that very point, and I think it matters. So that is one of India's advantages, and one of the disadvantages that a lot of the other Commonwealth countries suffer.
It's a quick one. India has got the directive principles. Could you what are your views on the directive principles? Has it helped governance in India? And we obviously do not have directive principles. And what are your views about the exclusion of directive principles from our constitution?
I'll distinguish between the preamble and the directive principles. I think, and I'll come back to the preamble, because to me preambles are good. But directive principles, I think the problem is that it may be frozen in a particular time. It may reflect a particular ideology that is time-centric, whereas the whole idea of a constitution is meant to be enduring. A constitution, take the American Constitution for example. The American Constitution is over 200 years. The Indian Constitution is over 75 years. Even our Constitution is 60 years. And it's meant to be for hundreds of years. So if you have a directive policy, that may be good when the country was founded, it may not apply as economics change, as social conditions change, as political conditions change, as life changes. I mean, take a simple example. No constitutional draftsman that I know of, that I can think of, would have ever thought of the internet and the technological and scientific discoveries of the 21st century. So if all these people woke up, if Jefferson woke up and Washington woke up and Nehru woke up and they're sitting here and we tell them, and Tunku Abdul Rahman is here, and we tell them about the internet and online media, and they will be shocked. They won't know what hit them. That's something outside their plan. So, because the world has changed so much. So I am not convinced about the directive principles. I mean, if you want it, you have it. You don't have it, it's not a big deal. Whereas the preamble is inspirational. So I'm quite happy because I got it in my paper. I didn't want to read it, but if I can, with your permission, High Commissioner, if I read the two preambles, and it will be a paper. First, I will read the Constitution of the United States preamble, and it reads this way: "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty." What wonderful language. "To ourselves and to our posterity, to ordain and establish this Constitution for the United States of America." I mean, whether they do all this with Mr. Trump there is something else, but the preamble is there. And now I come to the India's preamble, which you read this morning. "We, the people of India, having solemnly resolved to constitute India into a sovereign democratic republic," I say that was the original words. In 1976, they added socialist, secular, and to secure to all the citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves the Constitution. So if you just listen to those words from the US Constitution and the Indian Constitution, they're obviously drafted by very, very clever people who are masters of polished prose, and they're very inspirational. Unfortunately, Malaysia didn't do that. There was discussion, but for some reason, we did not have a preamble. So I am for, and I think there are a few countries which have had preambles. So I think a preamble is a good idea, but a directive policy, I'm not so sure.
Tan Sri, it's our honor and privilege to hear you on this important Constitution Day. I have a very basic question, actually. I've read a lot of reviews of your books, and is justice in the wilderness? So I would just like to know, where did you get the inspiration of these words, especially the second word, wilderness?
Well, again, justice, I'm glad. To be honest, I'd forgotten about the Indian Constitution's preamble when I chose the word justice, but I'm happy to see the founding fathers of India describes justice in their preamble as justice, then they have social, economic, and political. So I certainly had that in mind, justice. When I chose the word justice, it wasn't meant to be just justice for the lawyers and legal justice. Certainly part of it, but I meant a wider thing. Wilderness was both biblical in origin, because it's a concept that appears in the Old Testament. So it will appear, I assume, in the people of the book. So I assume the Jewish Torah would have it, and the Muslim book will also have it. So there is that part of it, the wilderness, and Moses in the wilderness is a good example that the Bible gives. And also in the political, but that's thousands of years ago. And you come to the 20th century, Churchill was in the political wilderness. So I think he often wrote, when the time he was out in the backbenches for 15, 20 years, he never thought he would ever get the call to become Prime Minister. He was Prime Minister in waiting for about 15 years. So he was in the political wilderness. So it was in that side, a combination of that I chose the word wilderness. Nothing magical about it. Thank you.
We may have time for one more question if anyone would like to ask any questions. Thank you very much, Tan Sri, for your time. Yes, sure.
Thank you very much, Tanshri, for this very lovely, very eloquent answering of the questions that have been posed. I'm not a constitutional expert, far from it, but I just want to touch on one aspect which that was about the directive principles of state policy. I think as a child growing up, reading social studies in our country, the books, from time to time, a chapter on directive principles of state policy would occur. And the teachers would always tell us that, look, don't forget, while the Constitution gives you fundamental rights, which are justiciable, and there are few which are non-justiciable, but you also have a responsibility to the state. And these directive principles of state policy captured an individual's responsibility towards the state, towards the society, towards the environment in which one lives. So this is one, I would say, in our context, it has been ingrained in the mindset of a student as one grows up. Second part of it is, again, the question always asked is about the individual rights versus collective rights. Now, this is a debate in itself. I think I spent almost 6 years in different capacities in the United Nations setting, representing Indian mission both in Geneva and New York. And United Nations is seized with this debate of individual rights versus collective rights, as manifested which of them shall have primacy. And this is where some greater debate occurs. This again boils down to the fact that if one were to have these directive principles of state policy equivalent, I think it would do a lot good, in a sense that it will also remind the citizens of the country from time to time, while you are seeking certain rights to be expected, certain justiciability of certain rights in the country, you also seek an accountability of yourself to the state and to the people at large. Thank you.
I didn't see it from that point of view. I see where you're coming from, because you've actually applied that when you were growing up and university life and working life. But so it's interesting, because when you talk about the directive principles and the duty of the citizen, I accept that the citizen just doesn't have rights; he has duty. Just to give a simple example, a citizen has a duty to pay tax. Simple example, and if there's war, he has to go and do conscription. So those are duties. But I think it's really relevant today in the COVID world, because when you have the vaccination debate, when people say, I don't want to take vaccination, that is taking individual liberties to its absolute level, forgetting that if you are going to mix with society and you're not going to be a hermit in a cave, then you have duties. That's an example of duties to your fellow men, because you may be a carrier or whatever. So COVID in the last 2 years has shown us that part of life, and I take your point, and I'll remember that next time over the directive principles. So if Rama asks me this question tomorrow, my answer will be slightly different.
Thank you very much, Tansri. We sincerely thank you for your time in engaging with our audience. May I now kindly invite the Deputy High Commissioner of India, Mrs. Archana Nair, to kindly propose the vote of thanks.
On behalf of the High Commission of India, Kuala Lumpur, and High Commissioner of India, His Excellency Shri B.N. Reddy, it is my privilege to propose the vote of thanks. At the outset, I would like to express sincere gratitude to our special guest for the evening, Tansri Tommy Thomas, barrister and former Attorney General, for gracing today's event and delving not only on the framing of the Indian Constitution, the achievements and journey of the Indian Constitution over the last 7 decades, but also its influence on the Malaysian Constitution. Thank you, Tansri, for also sparing your valuable time for engaging with our audience. We deeply appreciate it. I also take this opportunity to thank members from the Malaysia-India Heritage Group, members from the Malaysia Bar Council, and all our distinguished guests, friends from the media, and friends of India, colleagues from the High Commission, for joining us this evening in commemorating the Constitution Day of India. Thank you very much.
Thank you very much, ma'am. Ladies and gentlemen, with this we have come to the end of today's program. I would like to thank you all once again for joining us today to commemorate our Constitution Day. We have refreshments served in the foyer outside. Kindly join us for the same. I wish you all a pleasant evening. Take care. Stay safe. Namaste. Jai Hind.